So the Supreme Court on Friday, 20th May, has passed an important order regarding the Gyanvapi Mosque case. It has said that the matter needs to be handled in the Varanasi court where it is currently being heard. It needs to be handled by a more senior and experienced judge who will be better placed to handle the sensitivities and complexities of the issue at play. And therefore, it has ordered the transfer of the case from the civil judge in Varanasi, who is currently hearing the matter, to the district judge there, who is a more senior officer. Now, in addition to this, the court has also said, has also passed a few other directions in its order, which are as follows. So first off, they have said that now that this matter is going to go to the district judge needs to, on a priority basis, decide the key issue, which is why this matter has even reached the Supreme Court, which is whether the suit, which was filed in Varanasi by Hindu devotees asking for a right to pray at the Gyanvapi Mosque at certain sites within it, that this suit, the maintainability of this suit needs to be assessed. It needs to be decided as a matter of urgency. And that means that the Order 7 Rule 11 application under the Code of Civil Procedure by the MASJID committee, which has argued that there is no right for this case to proceed, must be decided at the earliest, which means that the district judge will now have to look at the question of whether or not this suit is barred by the Places of Worship Act of 1991. In addition, the Supreme Court has said that its interim order dated 17th May, which, if you might remember, in that order, the court had said that it will that the protection of the area where a shivling was allegedly found during the video survey of the mosque needs to be protected, but at the same time, restrictions must not be imposed on the entry of Muslims to the mosque or their ability to pray. So the Supreme Court has said this interim order will continue to remain in force till that Order 7 Rule 11 maintainability issue is decided, and will continue to remain in force even after that, so as to ensure that there is time for parties to file any relevant applications or appeals as required. They've also said that since there is a key issue here involving the ability of Muslim worshippers at the mosque to perform the wuzu ritual, which is sort of the ritual washing of hands, which is required for their prayers, which is being impeded because perhaps of this discovery of the shivling and the sealing of the area where it was supposedly found. They have said that that arrangements have to be made by the district magistrate in consultation with the Masjid committee to make sure that this is possible. Meanwhile, the order of the civil court in Varanasi, which had passed an order for the sealing of that area, has to be subsumed and understood as explained and clarified by the Supreme Court on the 17th of May, which again, to reiterate, means that there can be no restrictions on the entry of Muslims. Now, there are no further orders passed right now by the court. It will now take up this issue after the vacations, that the Supreme Court is now on vacation from today onwards. The matter will be taken up after it resumes its from vacations in July. By then, the court is also hoping some progress will be made on the Order 7 Rule 11 application, the decision on whether this suit is maintainable because of the Places of Worship Act. And we'll then be seeing whether the Supreme Court will have to pass any more detailed orders, because if the district judge does allow the case to proceed, then this matter will have to be taken up further by the Supreme Court. Now, the main issues in this case, obviously, as we mentioned, the key issue is here that you've got these Hindu devotees who are arguing a right to pray at the mosque. They're saying they currently have access to it one day in a year. They should have access to these certain sites every day, and they must be allowed to offer prayers to any deities they want. This suit was filed in Varanasi before a civil judge. It's been contested by the Masjid committee, which says that it is barred by the Place of Worship Act, which forbids conversion of any place of worship to another for a kind of place of worship if that place of worship has been in existence since before 15th August 1947. It also talks about barring of suits and of changes of the religious character of a place of worship which was in existence since before 15th August 1947. There are questions being asked about whether or not that act applies. Even Justice DY Chandrachud of the Supreme Court today suggests that maybe there is no harm in allowing a determination of the religious character of a place of worship, for instance, through a video survey as ordered by the Varanasi court earlier in April. But this matter still remains to be now taken up first by the district court and may then end up back in the Supreme Court as well. In the meanwhile, there was a concern raised about the fact that there is a particular design about changing the status of a mosque which has been in place for 500 years here, the Gyanvapi Mosque in Varanasi, and that the effects of the orders passed by a Varanasi court allowing a video survey there and then allowing sealing of part of it could have a greater, more egregious effect on the ground, not just in Varanasi, but elsewhere as well, lead to spreading of communal disharmony and defeat the purpose of the 1991 Places of Worship Act. These issues have not yet been addressed by the court, and they will have to be taken up and perhaps looked into when the court resumes hearing this back in July. Stay tuned to the Quint for all the updates from the Supreme Court and the Varanasi court, now with the district judge in Varanasi, who will be having to look at all these matters afresh.